Welcome to the session on the Payment of Gratuity Act 1972. See, gratuity it means is a gracious gift for a person who renders meritorious and creditable service. And the donor cannot be compelled to make a gift, but in industry law it has become a different thing. Now it has become a legislation and a law where you are bound to pay the gratuity. The question of meritorious other things will not arise. It's only a question of continuous employment, because work for a number of years, yes, you have to pay the gratuity by compulsion. There is no doubt about it. It does well. Then payment of gratuity is a piece of beneficial legislation that way, made in the interest of the employees, and it's the intention of legislation the employees should not be allowed to be exploited so as to contract out the rights conferred upon by the Act. It's the only with intention this gratuity Act have been filed. So this activity, the aim of the Act is to provide a scheme of payment of gratuity to employees in factories, mines, oil fields, plantations, ports, railway companies, shops and other such other matters connected with and incidental they do. Now coming to applicable Act, it's applicable to all the establishments. If 10 or more persons are employed, the Gratuity Act becomes applicable. It can be shop and establishment act, it can be any business activities. It has a wide meaning, as you know, we have discussed in so many legislations. It has got a wide application. It covers all types of activities of business activity employed more than 12, it becomes applicable. But once the Act becomes applicable to an establishment, if the number falls below 10, still the Act continues to follow. No employee cannot get out of his liability. Here the completed year of service means a completed year of service of 1 year. Then continuous service has been elaborately defined in the definition of 2A, which I will share with you shortly. Before that, let's see the employee. Employee means any person other than an apprentice who is employed for wages, and whether terms of such employee express or implied to any kind of work to which this Act applies, he continues. Here, if you see the definition of employee, it's a very, very wide definition. It means that anybody employed for any kind of work in the establishment is an employee. He can be even the topmost person in the organization to the lower rank of the organization. Everyone is covered under this Act. Wages means here also it is all wages, but only limited to basic and dearness allowance. All other allowances are excluded here. It does not include any bonus, commission, house allowance, overtime wages or any other allowances. Hence it is limited to only basic and dearness allowance. So let me be very clear, here the wages means it is purely the basic and dearness allowance. A family in relation to an employee shall be deemed to consist of, in case of male employee, himself, his wife, children, whether married or unmarried, dependent parents, and all these people are included. In case of female employee, herself, her husband, her children, whether married or unmarried, her dependent parents and dependent parents of her husband, and widow and children of her predecessor, if any. So everybody is included here. Then here coming to definition of continuous service, it was amended subsequently after one Supreme Court decision. This definition was redefined by the amendment. If you see this definition, the continuous service, it includes all absence of various types of absences. You can name anything. For instance, I can just read out the absence on account of sickness, accident, leave, absent from duty without leave, not being absent in respect of which an order treating absence or breaking service has been passed in accordance with standing orders, rules or regulations governing the employees of the establishment, layoff, strike or lockout or cessation of work, not duty any fault of the employee, or such interruption or service are rendered before or commencement. So if you see this definition, it means that not any type of absence is excluded from here. It means that it's deemed that he is in service, that's all. Even if a person absent for 100 days in a year, he is deemed to have completed continuous service in that year. That's all, because his absence, everything is covered under this act. So this is the important thing in this particular legislation. Then here, in the case of a seasonal worker, a continuous service with the meaning of for a period of 1 year and 6 months shall be deemed to be in continuous service under the employer if 190 days, in case the employee who is employed in the underground mine and he established work for less than 6 days in a week, if you work for 190 days, he is deemed to have completed 1 year. In case of 240 days in any case, it is completely deemed to be continuous service under the employer. An employee actually worked on an employee shall include days of he has been laid off under an agreement, all things are included. He has been leave with wages earned with the previous year, has been absent due to temporary disability caused by accident, in case of female employees, have been maternity leave. All periods have been taken into account, shall be taken into include as days work. It means that everything to be included in short. Then payment of gratuity. Payment of gratuity shall be payable to an employee on termination of employment after he has rendered continuous service of not less than 5 years. That's the minimum thing. On his superannuation age, or on retirement of resignation, or his death or disability due to accident or disease. You see, provided that the completion of continuous service of 5 years shall not be necessarily applicable where the termination of employment of employee is due to death or disablement. It means that if a person has worked only for 3.5 years and he dies or becomes totally disabled on account of employment injury, then he is eligible for gratuity for that particular period. In other cases, minimum 5 years is a must. This is what it says. In case of death, the gratuity payable to his nominee. If no nominee is made, or to his legal heirs, or no such nominees are legal heirs or minors, the shares shall be deposited with the controlling authority who shall invest the same for the benefit. So here the provision has been made that the gratuity amount in case of death should be paid to the nominee. If nominee is available, legal heirs. If the legal heirs appears to be the minor children, then the employer has to deposit the money with the controller, authority and the controller, then who shall invest the same in one of the savings account and guard it and then pay as and when it becomes due. The calculation of gratuity. Calculation of gratuity is very simple. Lost on salary to be taken into account, multiplied by 15, divided by the number of complete years of service and divided by 26. The 26 is very, very important. Whatever be the number of working days in the company, divisible factor is 26. Even in case of companies working for 22 days in a month, the divisible factor still remains 26. So this is very important. While number of years, service of 6 months and more shall be counted as 1 year, and service less than 6 months shall be ignored. This is exactly the calculation. Then here also, the gratuity can be forfeited wholly or partially under the following circumstances. If a person is terminated or dismissed, this is very important. If a person is dismissed or terminated due to acts of willful commission or negligence, causing damage or loss or destruction of property of the employer, or termination of service is due to riotous or disorderly behavior for any other act of violence, or termination of service for any act which constitutes an offence involving moral turpitude, provided such offence is committed during the course of employment, then the gratuity can be forfeited wholly or partially. So here, an employee will be entitled to gratuity even for the year when he has not worked for 240 days in view of the definition of continuous service. As I told you already, the definition of continuous service is such a wide enough. Even though a worker has not worked for 240 days, you have to take it as 1 year. This is as per the even recent clarification by the Madras High Court in Kolarkumba Estate versus Sagundiltha. This one supports this. Then there is a provision for compulsory insurance. This is a very good provision in fact, because many times what happens, supposing the employer becomes bankrupt and is not able to pay the gratuity, then in such case the compulsory insurance concept was introduced. It means that to obtain the insurance policy of NHRD or any other prescribed insurer, it is mandatory. But however, what happened, the central government has not brought this provision into force at all till now. They are not brought it, except only in Kerala, government has amended this scheme and they have made it mandate, and even there, the contractors who are engaged in contract labor, they have to obtain compulsory insurance policy for the workmen. So they have done it, but other states have not yet done, and even the central government has not notified. Then nomination. Nomination is very important here because each employee has completed 1 year of service shall make the form in the nomination in the form F. Then it is the duty of the employer to verify, certify, and then sign, attest, and give one copy of the nomination. Then if there are changes in the family, the employee has to be intimated to change the nomination as and when there are changes in the family. He may acquire a family, that he may get married, or there may change his family, in the sense his spouse or somebody dies in the family. Then changes should be incorporated in the nomination, because the law is very clear that the nomination, if changes are not made, the earlier nomination stands null and void. This is very important because particularly for bachelors who make a nomination in favor of parents and subsequently get married, and nomination is not changed accordingly because wife is the immediate legal heir, and the nomination is not made, then the earlier nomination made, because since he has acquired the family by marriage, the earlier nomination made by him becomes null and void. So this is very important to ensure that we educate workers and people to see that the changes in nominations are kept up to date. The determination of amount of gratuity under Section 10 and subsequent payments have not very rigid in the sense that they are quite flexible, but the main responsibility of the employer to ensure the gratuity is paid within 30 days of the gratuity coming due. That's very important. The formalities of getting the application form from him and intimating him is all exactly fine. But that's not an excuse if there is delay on account of that. The employer has to take initiative to ensure that he pays the gratuity within 30 days from the date of when it becomes due, he has to pay, otherwise interest will have to pay. Then here Rule 8 also says notice of payment of gratuity, that form L, but even if the claims is not admissible, the employer shall send notice in form of reason thereof. Both form L and M are sent to controlling authorities. Very important. Then mode of payment of gratuity, yes, by check or deed to the employee, nominee or legal heir as the case may be. Then intimation also to be sent to the controlling authority. So though the forms have been prescribed, everything is there fine. But at the same time, the responsibility of the employer to ensure the payment of gratuity is done within 30 days. That's extremely important. And most important thing is, the final payment of gratuity has to be in form L, and it has been sent to the gratuity authority for information. This is a mandated clause. Then in case of dealing with application for deduction, the Rule 1 to 80 elaborated deal with proceeding in the manner claimant should be heard and also for an opportunity to hear the employer according to issued directions. Here in case the employer denies or has got any reason to say that the gratuity is not payable or shall not liable to pay, etc., if anything comes, based on the petition, there will be inquiry held, proceedings will be conducted by the gratuity authority, and accordingly the employer also will be given a chance, will be provided a chance to come and appear before him and hold an inquiry, and then only he will pass an order. The inquiry will be, under this Act, is quite judicial. The proceedings shall be in accordance with the Civil Procedure Code with power vested with the controlling authority. These cases comes up in case of the employer denies the gratuity or wants to pay less than the gratuity for any reason, obvious reasons. These questions do come up, and based on the application, the authority shall inquire into this matter and then give directions. Gratuity is protected from attachment of any court, any civil court. They don't have authority to attach the payment of gratuity against any debts or whatever it is. So the court cannot attach or pass any decree in this issue. Now here, of course, there are some case laws I have combined. I will just share with you. An establishment employing less than 10 will not be covered under the Act. That's very clear. An establishment has a wide meaning to include commercial establishment as well as non-commercial establishment like even Red Cross Society. Red Cross Society is also covered. Non-governmental education institutions are covered under the Act. Because here, recent amendment also it says that the teachers are also entitled to gratuity. When teachers are entitled to gratuity, even by amendment of the Act, obviously, education institutions also get covered under the Act. This has been given ruling in 2009, 2010 and 2010 again in various high courts like Rajasthan High Court, Delhi High Court and Bombay High Court. You can see here. A teacher is covered under the Act. There are 3 decisions I have quoting here, M. Singh Chabra of Madhya Pradesh High Court, then Vidarbha Youth Association of Bombay High Court and Shamraj Udupa Mangalore of Karnataka High Court. All the people have said, all the courts have held very clearly that the teacher is covered under the Act. Then contractual employees are also entitled to gratuity. Contractual employees. A person entering into contract of service can be a fixed term contract, extended by year on year, then definitely he is entitled to gratuity. Even a daily worker, daily wager, if he has worked for 5 years, he is entitled to gratuity. As per Vishwavidyalaya was Nagpur case in Pune case. Then Ahmedabad Municipal Corporation Kandibai in Gujarat High Court. Casual workers working for more than 5 years, they are also eligible. Then forfeiture of gratuity without notice to employee and passing orders not sustainable. As I said already, if you have to forfeit the gratuity, you have to follow the process of holding an inquiry, you have to observe the principles of natural justice before you pass the order. That's exactly Bombay High Court has said. Forfeiture gratuity against prescribed misconduct under the Act. That's very important. You can forfeit the gratuity only what is prescribed under the Act. Only for those misconducts you can forfeit the gratuity, otherwise no. Then embezzlement will constitute a moral turpitude. Embezzlement fund definitely amounts to moral turpitude and you can always resort to forfeiture of gratuity. Then again Kerala High Court has done the same thing. Forfeiture of gratuity without show cause notice is not proper. Then again Madras High Court also has said gratuity not vacating residential quarters cannot be held. Because some employees also, if they don't vacate the residential accommodation, we will not pay gratuity. This case came before Navy Limited Corporation and Madras High Court said no, you can't stop it. Then gratuity cannot be denied on the ground that the employer's legal heirs have not vacated the company. Again, Gujarat High Court has said the same thing, they had the same view. Then gratuity can be effected only on conviction of an offence of moral turpitude. Karnataka High Court in KSRTC versus Mahale. So he says that only on conviction you can do it. Just because he has been charged and case is pending, you can't forfeit the gratuity. He has to be found guilty and convicted in a court of law for that. Then only we can invoke the cause, otherwise you can't invoke the clause. When an employee works for 20 days in a month, his gratuity shall be carried 26 days in a week basis because the section very clearly says divisible by 26. So we can't say that it should be divided by 22. So 26 the basis in the case of Carney Elevators versus ALC, Madras High Court decision on this matter. A trainee will not be entitled for gratuity for training period. In case of Yalama Cotton Mills, gratuity as payable to an employee for legal aid cannot be adjusted against loan. We can't touch that gratuity for any other purpose, we can't adjust against any loan. For delay in payment of gratuity, an interest of 10% shall be paid. I told you already within 30 days, the gratuity has to be paid by the employer. If there is delay, yes, he says 10% shall be paid. If the employer fails to pay the gratuity within 30 days, statutory interest will have to be paid. Same thing, whatever related in Kerala High Court and Delhi High Court, same thing is repeated in Jharkhand High Court also. Break in service due to absence will not deprive gratuity. See, I give the example of one High Court case. Even though he has not worked for 240 days in a year, still he is entitled to gratuity. So here is a break in service due to absence will not deprive the gratuity for this. Gratuity, if not by the contractor, principal employee shall pay. This is a very important decision in the case of Mittal Thermal Company, Madras High Court decision. They have held that gratuity, if not by the contractor, the principal employee shall pay, but you have got liberty to recover that money from the contractor's bill. So this is about the Payment of Gratuity Act. Thank you.